to the IAPP web conference, FTC Rulemaking, a solution for federal privacy regulation, brought to you today by Botts. My name is Dave Cohen. I'm the IAPP Senior Knowledge Manager, and I'm going to be your host for today's program. And we're going to get started with the conversation in just a few minutes, but before we do, I have a few quick program notes for you. First off, if you're an IAPP certified privacy professional and you're registered through our site, we will automatically grant you 1 CPE credit toward the upkeep of your certification. You don't need to do anything. We'll take care of that for you. And if you're listening in and you didn't register through the website for some reason and want that credit, you can still receive it by filling out a very easy to use form that's on our site in the certification area. Also want to let everybody know that today's program is being recorded and will be posted on the IAPP site within about 48 hours of this live broadcast. So you can look for it there in your My IAPP section of the site in the upper right-hand corner. And when you go to that page hosting the recording, underneath you'll see a live link that says download presentation. And if you click on that link, you'll be able to download it and view a PDF of the slides that you're about to see that we're going to use for the conversation. Also want to let everybody know that you're welcome to submit questions throughout the program. So please type those into the chat that you can find in the bottom center of your screen, and we will monitor throughout, and we've designated a little bit of time toward the end of the program to handle those questions. So with that, and without any further delay, I would like to introduce today's panelists. And so I'd like to introduce today's moderator for today's program. Maureen Ohlhausen chairs the Global Antitrust and Competition Practice at Botts and is former acting chairman of the Federal Trade Commission. Maureen's practice focuses on antitrust, privacy, and data security and consumer protection investigations and litigation, both in the US and abroad. She advises top-tier clients across a wide variety of industries, including technology, retail, telecommunications, social media, and life sciences. Maureen, it's a real pleasure to have you moderate the panel today. Welcome.
Thanks so much, Dave. I'm delighted to be here, and thank you so much to IAPP for hosting this very important and timely discussion. I'm very honored to have on the panel with me Commissioner Christine Wilson of the Federal Trade Commission. Commissioner Wilson was nominated to the FTC by President Trump and started her service in September 2018. Christine brings a wealth of experience to the job, having previously served at the FTC, including as the Chief of Staff to Chairman Tim Muris, and she is a very well-known thought leader on privacy issues. We're also so fortunate to be joined by Danny Weitzner, who's the founding director of the MIT Internet Policy Research Initiative, and the principal research scientist in the Computer Science and Artificial Intelligence Lab. Danny brings also a wonderful perspective on these issues. He was the Deputy Chief Technology Officer during the Obama administration, worked in the White House, and was responsible for many privacy initiatives, including, I believe, the Consumer Privacy Bill of Rights. So I'm so delighted to have such two wonderful, thoughtful people to discuss this very important issue. So if we go to the next slide, here's just a quick outline of what the program will be. We're going to cover FTC, history, what its authority is, what are the possibilities of what it can do with rulemaking, and compare that also to legislative options, and then also think a little bit outside the box and what are some of the other options beside rulemaking or federal or state legislation that we should be considering. And we'll also save time for you in the audience to ask us questions. But we're going to start off, and we go to the next slide, with a brief poll. So what do you in the audience think is the best approach to privacy regulation? Federal legislation, state legislation, FTC rulemaking, or industry self-regulation? So as the numbers are calculating here, I think it's very interesting. I don't want to let it go on too long, but I think we're seeing a kind of an overwhelming preference for federal legislation. I think to me, it looks like 88%. I think that's a very interesting result, and hope that we can give you some insights as the discussion progresses about these different options: federal legislation, state, FTC rulemaking, and industry approaches too. So turning to the next slide, I want to talk about why now. Why is this such an important topic right now? And I'm going to invite Commissioner Wilson to start off, and I hope Danny will also weigh in on why are these such important topics and why are we talking about FTC rulemaking in particular right now. Commissioner Wilson?
Well, thank you so much, Maureen, for inviting me to participate today, and also to IAPP. And of course, I begin with the caveat that the views that I express today are my own. I don't necessarily speak for any other commissioner, and I do not speak for the commission. So as many of you know, since its first privacy report in 2012, commissioners on both sides of the aisle have urged Congress to pass federal privacy legislation. And in the interim, the FTC has brought hundreds of privacy and data security cases. Now, our orders embody a set of privacy best practices and data security best practices, and we seek to hold businesses accountable for the choices that they make. In fact, Professor Solov has said that the Commission's body of orders has created a common law of privacy in the US. And while I'm proud of what the FTC has done, the reality is that we're doing this work using a statute that was not designed for this purpose. And we do have some sector-specific laws like HIPAA for health data, but evolving technologies create gaps in the coverage of those laws. For example, HIPAA had gaps in it even before COVID, and the pandemic has just served to underscore how significant those gaps have become. And so in the absence of federal privacy legislation, I submit to you, businesses need certainty and predictability, particularly in light of this growing patchwork of state and international privacy regimes. I think Danny's going to touch a little bit on that. But having been in-house myself, I understand the compliance costs become tremendous. And sometimes businesses are forced to choose to exit certain markets or to decline to enter markets at all because of the compliance costs. And in fact, there are impacts on competition in a sector where, frankly, people are already concerned about too little competition. Furthermore, consumers need transparency about how their data is collected and used and shared. Only if consumers understand what data is being collected and how it will be used can they make informed trade-offs about the costs and benefits of using different goods or services. And of course, the concerns extend beyond the commercial arena. I know that some of you are from outside the United States, so I will just be a little more explicit here. In the United States, under our Fourth Amendment, we're protected from unreasonable search and seizure by the government. Whether a search is viewed as reasonable or unreasonable depends on societal expectations. In other words, would an individual have had a reasonable expectation of privacy? But consumers have become so accustomed to surrendering extensive data through their daily use of phones and computers and digital assistants and other connected devices. So if citizens know and accept that nothing is private, then they have no reasonable expectation of privacy, and the Fourth Amendment gets eviscerated. So Congress needs to act because businesses need predictability and certainty, and consumers need transparency, and our civil liberties are at stake. And the US needs to lead and have a seat at the table. But in the absence of legislation, and this is where the rubber meets the road for today's discussion, I testified recently before the Senate Commerce Committee that I would support then acting Chairwoman Slaughter in considering an FTC rulemaking pursuant to what we call our Magnuson-Moss procedures. And look, this isn't my first or my second choice. It's not even the third best option for how this should be handled. First, Congress is comprised of elected representatives who are best situated to make the societal trade-offs that are necessarily involved in privacy legislation, not commissioners who are nominated by the president and confirmed by the US Senate. Second, as a general principle, and if you've ever talked with me for more than 3 minutes, you know this to be true. I believe that free markets deliver the best outcomes. Regulatory frameworks have a tendency to stifle innovation and competition, and they frequently have significant unintended consequences and may not even ultimately satisfy the goal for which they were designed. So I have a lot of reservations about rulemaking, but here I do believe there is a market failure and that the asymmetries of information between consumers and businesses can't be resolved through the market alone. And so in the absence of congressional action and in the face of these imperatives that I've described, I have reluctantly come to consider whether we should begin a privacy rulemaking proceeding at the Federal Trade Commission. We're going to talk about what we call the MAGMOS process. It has many steps. And if we do that, if we embark on that process, then we can begin gathering input from stakeholders. And if Congress acts in the meantime, which would be ideal, the input that we've collected from stakeholders could inform the legislative process and also our policy and enforcement work. Look, I would like nothing more than to embark on a rulemaking and to have that FTC rule superseded by a federal statute. But we've been waiting for Congress to act for a long time, and in the absence of congressional action, I have come to support the prospect of a privacy rulemaking at the FTC. Danny, you wanted to talk about the patchwork?
Thank you, Commissioner and Commissioner. It's a pleasure to be with both of you, and I'd extend my thanks also to IAPP for this discussion. I want to just begin with a bit of a historical reflection about where we are, and as a way of answering Commissioner Ohlhausen's question, why now? The reason why now is that for quite some time, really since the 1970s, we've lived effectively in what I think of as a bipolar, that's a geographic term, not a mental health diagnosis, a bipolar privacy world where there's always been a set of legal and regulatory and policy impulses from Europe, and there's been a sort of countervailing set of impulses from the US, based in many ways on a common set of principles, but with different strategies for implementing them. Our very distinguished colleague, Peter Hustings, often would talk about the fact that in this bimodal, bipolar privacy world, Europe provided a lot of the principles and the US provided a lot of the enforcement energy, and that all worked out into a somewhat healthy balance. Well, as we understand, we no longer live in that world. We live in a unipolar privacy world effectively today, if we exclude China, where for the most part, enterprises have to pay attention to what's in the GDPR for a whole variety of reasons. And as much as I actually like the GDPR, I like a lot of the principles in it. I think it's got a very forward-looking approach to privacy that I think is learned from a lot of the experiences we've had over the decades. I think it's not healthy to have one single governing body, which is really regionally and nationally based, controlling the entire privacy debate, being the sole forum for discussion of privacy. And I think one of the reasons why now is that we need a diversity of privacy views, and it's time for the US to assert its voice in the privacy regulatory environment. We are quite literally missing in action on questions of commercial privacy. I think we remain a strong force, as Commissioner Wilson said, on questions of surveillance and civil liberties, much stronger than many of our democratic allies. But I think we all understand as privacy professionals that any set of legislative rules for privacy is by definition high-level set of principles, and their meaning comes from dialogue and from enforcement. Again, following Dan Solov's common law of privacy model. But right now, that process is only happening in one place. It's happening in Brussels. It's happening in the other capitals of Europe. And I commend that process, but the US should have a voice. And while I don't want to sound nationalistic, sometimes laws have to be a little bit closer to the institutions and the people who they govern and who they are meant to protect. And right now, the main energy for privacy laws, for our evolving understanding of what privacy means, is happening a little too far away, and with a somewhat of a lack of diversity. I think this is important also because the GDPR, as all of you know, reaches quite broadly into a whole range of new technologies that I think weren't actually contemplated when it was written, particularly the application of artificial intelligence and machine learning technologies are going to be substantially affected by both the GDPR and perhaps subsequent regulations and directives that come from the Commission. And in all candor, the GDPR is based on some now somewhat technologically outdated understandings of machine learning, specifically the view that every single machine learning model is going to be somehow explainable or interpretable as a way to produce fairness and transparency. We now understand in many cases that that's quite difficult to do, and we're going to need different approaches to achieving the underlying fairness and equity goals that I think the GDPR quite legitimately has. Just one more reason why the US needs to be actively in this game, and we can't be in the game without the actual exercise of legal authority. As Commissioner Wilson said, that has to reach beyond the current boundaries of the FTC Act, as effective as that has been for a long time. So I'll turn it back to you, Maureen.
Great. Well, thank you. Thanks to both of you. You laid out the issues, so well, and the importance of getting things right. But before we talk further about where things should be going, I think it makes sense to give a little sense of what tools we already have, and what is the history of using those tools. So Commissioner Wilson mentioned that the FTC Act, which the agency has used quite, I think, creatively to cover a lot of privacy issues, is really not necessarily designed for that. So it covers an unfair practice, and it's got a very general definition of that. It causes substantial injury to consumers. The consumers can't avoid it reasonably, and it's not outweighed by countervailing benefits. And then the other source of authority is the FTC's ability to stop deceptive practices. So going to the next slide, we want to give you, we're going to talk about rulemaking. So now Commissioner Wilson already mentioned MAGMOS rulemaking. So we're going to give you all a little test. What is MAGMOS rulemaking? So if you would vote and tell us your views on what MAGMOS rulemaking is. All right, I see the numbers going up and down. We have a fairly, I think, sophisticated audience, and they seem to be understanding pretty well what that is. So, okay, so I'm sorry, I've got to put my cheaters on to read this. So most of you got the right answer, that it's a process that applies only to the FTC for historic reasons, which we'll get into more of what those reasons are. But it creates, the MAGMOS creates some very interesting dynamics, I think. So if we go to the next slide, I'll just give a brief background on what are those dynamics. So it was the MAGMOS Warranty Act was enacted in 1975. And while it authorizes the FTC to promulgate legislative rules under Section 18 of the FTC Act, it was done really not to empower the Commission so much as to put some important guardrails in place for the commission. And so it has some specific requirements that you don't see necessarily in streamlined, what we typically call streamlined APA rulemaking, which is just notice and comment. So there are these additional requirements of defining with specificity acts or practices that are unfair or deceptive. If we also go to the next slide, there are also, this is how it differs. There are some extra steps that are put in. So it's a hybrid rulemaking. And these extra steps are some of these extra guardrails. So there has to be an advance notice of proposed rulemaking, not just a notice of proposed rulemaking. And it has to include much more detailed particularity of the text of the rule and alternatives. There have to be oral hearings before a presiding officer upon request, and has provisions that allow a lot more input into the rules, and it requires the FTC to maintain records, and just sort of makes it a more onerous process. So if we go to the next slide, we're going to turn it back to Commissioner Wilson to talk a little bit about how MAGMOS has worked in practice and how it might come into play for a privacy rule going forward.
Absolutely. So let me just first of all make sure I am unmuted, which I am, and then note that Maureen is correct. Section 18 of the FTC Act, that we call colloquially MAGMOS, has many thorough, complex procedural steps. The framework was designed by Congress to impose constraints on the FTC after the FTC went on a rulemaking binge in the 1970s, and a bipartisan Congress came to realize that the actions of the FTC were incredibly harmful. And so the end goal of the MAGMOS process is to ensure first that FTC rules will be based on a thorough evidentiary record that clearly demonstrates prevalent unfair or deceptive practices. And second, that the promulgated rules will directly address those practices. When prior to MAGMOS, rulemaking was undertaken, the harms were rather nebulous, and the restraints that were imposed sometimes had absolutely no connection to even those nebulous harms. And so given the difficulties with using MAGMOS, in fact, it has been little used. There were a number of rules that were ongoing when MAGMOS was enacted. Some of those were grandfathered in under the old APA process, but others were far enough along that they needed to be brought into the MAGMOS process. Several of the final rules or amendments that were undertaken under MAGMOS were actually overturned by courts. Those that did progress actually took an incredibly long time to complete. I read a very interesting article by Professor Lubbers, who took all of the periods of time used for non-MAGMOS rules and then for MAGMOS rules, and compared them. And under Magnus and Moss procedures, rulemakings take a much longer time frame. And so the fact that it is little used and the fact that it does take a longer time actually comports with what Congress intended, which is in the face of willy-nilly rulemaking and activity by the FTC, Congress wanted MAGMOS to serve as a constraint so that what the FTC did do would be rigorous and thorough. So now that we have a little bit of that context, let's talk about what a privacy rulemaking might look like under MAGMOS. So realistically, it could run the gamut from something that's very narrow and surgical to something that is really broad and sweeping. And I can describe for you just my own views of how those three buckets of limited and moderate and significant might play out. Obviously, these are my own musings and don't reflect anything that is under discussion inside the commission. So if we take a limited approach, we could codify existing privacy cases so as to secure money and ease litigation burden for cases that relate to the common types of privacy injuries that you're all familiar with: physical injury, financial, reputational, unwanted intrusion. And in a similar vein, we could codify existing data security and privacy cases to require a sliding scale of reasonable privacy practices and/or data security practices. So what might that entail? Reasonable data collection limitations, sound data retention and disposal policies, data accuracy efforts, and so on. And we could also draft provisions that encourage self-regulatory codes or create safe harbors. If we move a little further on the spectrum, in a moderate type of approach, potentially we could map out limitations on data collection. We could specify permissible or unreasonable uses of data. We could identify third-party sharing parameters, or we could address topics like data brokers and cross-device tracking. And then if we go the furthest, if we picture a sweeping approach, we could essentially think about prohibiting problematic behavior in advance for the most high-risk practices, the most extremely sensitive data. So in other words, those kinds of data whose use consistently is likely to cause harm, or those practices whose undertaking would consistently create harm that outweighs benefits. And topics could include facial recognition, biometric data, and Commissioner Slaughter recommended covering algorithmic accountability. And so you can imagine the breadth of topics that could be covered in a MAGMOS privacy rulemaking. And of course, I've described that it is a lengthy undertaking. And of course, the more topics you include, the longer that process becomes. Back to you, Maureen.
Thank you. Danny, did you want to weigh in on this as well?
Yeah, just one note. You know, it's interesting to reflect on the fact that the original Obama era Consumer Privacy Bill of Rights did not include any significant reliance on rulemaking, MAGMOS, APA, or otherwise. And that was really for a specific reason. It's because we actually thought at that time, based on a lot of input from a lot of stakeholders, that having a broad set of privacy rights laid out in statute and then enforced by the Commission was likely to lead to a more responsive, a more flexible evolution of what privacy law actually means. I obviously this begs the question that we'll get to later about private right of action and perhaps state authorities, which we certainly factor into this dynamic. But I personally am not persuaded that it helps consumer interests, particularly, to be overly reliant on rulemaking. I also think rulemaking is inherently a more political process, and I think would have would tend to politicize the FTC in a way that I think it really admirably hasn't been for decades and decades. I think you look at the Federal Communications Commission, by contrast, which is essentially all rulemaking, and it takes a long time to resolve issues. Questions become very political very rapidly, and I'm just not sure that helps us. I'm speaking a little bit, against my progressive type that, tends to like rulemaking authority, but I'm not sure it helps consumers. And we can obviously get to that more when we come to the discussion of legislation.
Great. Well, thank you so much. And that was, I think, for both of you, really valuable perspectives to understand this isn't necessarily just some like magic wand that the FTC forgot about, right? And that needs to be brought back. So if we move to the next slide, so we've talked about rulemaking, and now we're going to talk about what are the possibilities and the limitations of privacy regulation compared to legislation, right? So we're going to talk a little bit about what the legislative landscape looks like. So going to the next slide, the state of play for federal privacy legislation has been a trend towards, I think, increasing support across the aisle for a federal privacy law. And you can see here are some of the very well-placed members of Congress who have been quite supportive of it. Congresswoman Schakowsky, Congressman Bilirakis in the House, and in the Senate, we have the chair of the Senate Commerce Committee, Maria Cantwell, Senator Blumenthal, Senators Blackburn and Wicker on the Republican side. So there is a lot of energy and interest, and over the past several years, somewhat competing, but often similar bills have been introduced. And some of the basics that these bills have are something that Commissioner Wilson has already talked about. They provide transparency to consumers about how their data is collected and used and shared, gives them some insights into that data, some ability to control that or to correct it, and also gives important enforcement capabilities to make sure that these rights are backed up with some enforcement ability. So if we go to the next slide, so right now you really do have a lot of stakeholders urging Congress to move forward with privacy legislation, and they are continuing to provide input. So in a really kind of unprecedented way, consumer and industry groups have come together in support of privacy legislation. I mentioned Representative Schakowsky. She's proposed a series of roundtables for stakeholder input, and I believe they're going to start next week. The proposed legislation and views by various groups have more in common than not, and we've seen a movement towards closer agreement rather than divergence. And in an era of polarization, there really is a unique consensus on the need for federal privacy legislation. But there are a few key sticking points that remain, and we're going to turn it back to Commissioner Wilson now to talk about her views of the state of play for federal privacy legislation and what some of these sticking points are. Commissioner Wilson?
Thank you, Maureen. So I want to address a couple of issues. First, as Maureen said, it is striking that we live in an era of intense polarization, yet everyone agrees, all stakeholders agree across the board, there should be federal privacy legislation. And there are questions about who the enforcing agency should be. Should it be the Federal Trade Commission, or should we move forward with a new data protection agency? And so I think on the next slide we see this question: should the FTC be the sole enforcing agency? Obviously, you can call me biased. I am working on my third job at the Federal Trade Commission. I worked as a law clerk during law school and then as chief of staff to Jim Muris, and now I am obviously serving as a commissioner. The agency has an incredibly strong foundation of experience and knowledge in this area. It was under Chairman Muris that we brought our first data security and privacy cases using Section 5. And the beauty of blending that experience in the privacy arena along with the Consumer Protection and the Competition Authority means that we see holistically the implications of our actions. There is data that shows GDPR obviously has a significant focus on privacy issues, but perhaps to the exclusion of an impact on competition. And so post GDPR, we've seen studies indicating that venture capital investment has dried up, and with the withdrawal of certain players from that market due to compliance costs, we've actually seen an increase in market share by the largest incumbents. And so the ability of the FTC to look holistically at both consumer protection, including privacy and competition issues, I think would create the greatest benefits for consumers. But there is an opposing view that there should be a data protection agency, perhaps with supervisory authority, and legislation has been introduced to that effect. So let me just talk for a minute about what legislation should do. Assuming it goes to the FTC, I think the FTC should be granted jurisdiction over nonprofits and common carriers. I think it should give the FTC the authority to impose civil monetary penalties. I think the FTC should receive from Congress the ability to undertake targeted APA rulemaking authority, as opposed to having to use the Magnuson-Moss authority that we've described. And I believe, in keeping with the mission of the FTC to focus both on competition and consumer protection, legislation should be carefully crafted to maintain competition and foster innovation, while also securing greater privacy for consumers. And then in terms of substance, what are we looking for? I think it's really important to include elements of accountability in federal privacy legislation. And so we have moved past notice and choice. There is no way that a human being can review every privacy policy for every good or service or website that they use and opt in or opt out. It is incumbent on businesses to assume a mantle of accountability with respect to the data that they collect and maintain and use. And so what does accountability entail? Leadership and oversight, risk assessment and mitigation, written policies and procedures, training, monitoring and enforcement, complaint management, vendor management. And I think federal privacy legislation could also consider restrictions for certain types of data, where the harm or the risk of harm is so significant that it will consistently outweigh benefits to competition or consumers. And we gave some examples of that as we were talking about Magnuson-Moss. And then if we can move to the next slide, slide 17, there are a couple of sticking points that Maureen mentioned. And the first of these is preemption. And this question entails a decision that Congress is going to need to make about whether a federal privacy law should limit state laws. And if you want to move to the next slide, we can quickly highlight the second area. Private rights of action. Should enforcement be limited to designated agents? And just to sort of give you a spoiler alert, I believe federal privacy legislation should include preemption and should not include a private right of action. The internet doesn't stop at state borders, and businesses need certainty in the ability to comply with one standard. With respect to private rights of action, during my legal career, I have seen the abuses of private rights of action by class action attorneys, both as outside counsel and as in-house counsel. And I fear that a broad private right of action will benefit and entrench the large players in the industry who can afford to defend against those actions. But I understand that these two issues, both preemption and private rights of action, are major sticking points in legislation. And I appreciate that reasonable minds can disagree on how to address these issues. To assist policymakers in grappling with these issues, I'm currently working with Professor David Hoffman, formerly at Intel, but now at Duke. He is supervising a group of public policy and law students who are researching private rights of action and preemption in other statutory frameworks. Some of those statutory frameworks are related to privacy and some are unrelated. And so they're looking at how the treatment in those statutory frameworks has played out. And the intent is to post this research on a public-facing website as it becomes available over the summer. And we want to make this research and the implications available to Congress and others that are working on these issues. In other words, we want to equip policymakers in Congress with different possible permutations of solutions so that we can get across the finish line for federal privacy legislation. In other words, we hear that private rights of action and preemption are sticking points, and we want to arm those decision makers with a variety of permutations they could use to come to agreement. And so I am really excited about the work that we are doing on this topic. Many thanks to Dave Hoffman at Duke for spearheading this. And we're planning an event for September 21st to discuss the research that we've done, our findings, and potential paths forward. And I look forward to sharing more about this project with you and with other stakeholders in the coming months.
Well, thank you, Commissioner Wilson. That we all look forward to that important research on that essential issue. So if we move to the next slide, we've been talking about federal legislation, but federal, it's not just on the federal level, right? States are also adopting privacy laws. This also impacts this issue of preemption. What would be preempted if there's a uniform, federal law? It's some of these state laws. So I think everyone is familiar with the California CCPA, followed by the CRPA. It's had some growing pains. I know hearing from people who are in the trenches trying to, adapt their business practices and processes to make sure they're compliant. It's been quite, I think a challenge for trying to comply with something of a moving target. We now have the Virginia Consumer Data Protection Act. It just passed in March of this year and effective in January 2023. So it is similar to California, but it's not exactly the same. And I think that also creates some challenges for businesses that operate across states. And then, another example, the Colorado Privacy Act. It, again, is similar, has some similarities to the California and Virginia acts, but there are some key differences. It has some heightened protections, and it prohibits the use of dark patterns. So you can see as these state laws begin to proliferate, it could be a very challenging landscape for all of you in the privacy field to actually implement these across your businesses. So I think interesting developments and perhaps some good things in these laws that could be adapted into a federal law. So definitely some useful I think learning going on from that process. So if we
could I just add one point before we get on to this? I just want to make one point about what I think is going to be important in whatever legislative framework. I understand, as Commissioner Wilson noted, that the kind of political hot buttons are now the preemption and private right of action questions, and those seem like the canonical, last questions that would get resolved if everyone's agreed on everything else. But I do want to point out one area that I think is really going to be an important test of whether the U.S. is legislating effectively on privacy or not. I think that we all understand that really the hardest privacy questions are questions about secondary use of data. Whether you're in an opt-in or an opt-out mode really doesn't matter. That all of the innovation, all of the new services, all of the scientific learning that we see have to do with actually uses that were not anticipated in many cases when the data was originally collected. I think the GDPR actually has a quite clever way of addressing this question through the legitimate interest provision. That is, it does allow some flexibility. I think this is close to Commissioner Wilson's accountability point, that if one is going to do something outside the expected with personal data, then one has to take responsibility for it. And of course, what the GDPR requires is that you actually make a case that it's a legitimate thing to do, even if it wasn't directly noticed or consented to. We had in the Consumer Privacy Bill of Rights a notion of respect for context, which also allowed some flexibility about how data was used. As long as it was related to the context, it didn't have to be identical to what was agreed to. And I think that while it's true that where the debate is very focused now on some of these kind of, I would say, legalistic and compliance questions, I think whether we legislate properly or not is really going to determine in part on whether we're able to find the right balance which is going to be a dynamic balance between protection of individuals' interest and the ability to do new things with data, which at some measure we all want, but we also want to know that there's protection around it. And I think if we could figure that out, the rest of the issues would fall into place.
Thank you, Danny. That's a really key point because we want to be sure that we are able to continue to evolve and provide and innovate and provide things that our consumers want and that are beneficial to society overall. So just as a wrap up to this part of the discussion, I wanted to turn to both of you to discuss kind of the pros and cons about legislation, whether state or federal, versus FTC rulemaking. So Commissioner Wilson, maybe we'll start off with you again, and Danny, feel free to add your views as well.
Thank you, Maureen. So we have laid out in a grid some of the pros and cons of legislation versus rulemaking, and we've done some brainstorming. And obviously, this list is not comprehensive, but I wanted to just call out a couple of issues. First, again, I have mentioned my general aversion to rules. So I think people's ears really perked up when I indicated even a willingness to consider privacy rulemaking, but that's because I do believe that there is a market failure here that we need to address. I would rather have Congress address this. As I've mentioned, the members of Congress are elected, and therefore they are better equipped to channel the will of the people when it comes to making the trade-offs that necessarily must be made in this area. And then I also want to underscore that there are drawbacks to rulemaking. I am not suggesting this or contemplating this with rose-colored glasses on. Maureen and Danny have talked about the risk of inhibiting innovation and stifling competition. And in fact, regulations pose those risks. Some of the detrimental effect flows from the time-consuming nature of rulemaking. So for example, take the FTC's current care labeling rule that specifies which care instructions can be placed on garment labels. Industry associations are continually developing new types of care instructions for both existing and new types of fabrics. But the FTC is woefully out of date in updating the rules. So several years of care instructions that have been adopted by the industry are not incorporated into the FTC's rule. And even more notably, the FTC doesn't acknowledge the existence of an emerging rival to dry cleaners, known as wet cleaners, which have the capability to do the job more cheaply and in a more environmentally friendly way. So our failure to put wet cleaners in the rule means garment manufacturers are less likely to create garments that can be cleaned using this technology, and due to lack of visibility, consumers don't know about and can't demand clothes with this form of cleaning technology. So we have to be very careful when we're doing a rule to design it in a way that doesn't inhibit innovation and stifle competition. And then just to underscore the fact under cons that this is a lengthy, resource-intensive, and time-consuming process. Unfortunately, rulemaking relies on a one-time snapshot of industry dynamics, but industry dynamics change and evolve, and the rulemaking process is by its nature lengthy and cumbersome. For example, our contact lens rule took more than 5 years to complete, and this rule is not an outlier. One study found that the FTC takes more than 5 years on average to do a consumer protection rule, and examples from rulemaking in other US agencies show a similarly slow process. But all the while, business practices are changing, new competitors are emerging, consumer preferences are shifting, and especially here when we're talking about the collection of data, we're talking about the dynamic digital sector. How can we avoid taking only a snapshot in time and allowing flexibility, and as Danny said, balancing the desire for privacy with the concomitant desire for the benefits that come from different ways of using new and emerging types of data. And so it's going to be really careful to, it's important for us to be careful to avoid prescriptive approaches as we undertake this task.
Let me just underscore one. I agree with everything the commissioner said. Let me just underscore one additional important function that legislation has, if it's written right. Legislation can provide baseline assurance to consumers that they are protected. Right now, there's actually, I would argue that U.S. consumers are, in many respects, not perfectly, but well protected by many FTC actions. But I think we see over and over again that individuals, citizens in the U.S., feel that no one is protecting them, and it helps to actually have some clear rights stated in law that people can look at, that they can talk about, that they can understand. I don't count out the value of rulemaking for all manner of purposes. There are technical details that need to be ironed out. There may be processes that need to be established. There are fine points, without a doubt. But I think that it is unlikely that rulemaking alone is going to provide the kind of baseline sense of confidence and protection that I think individuals really need in this society, and that we see from survey after survey and all kinds of consumer behavior that indicates a sense that people feel they're kind of on their own with respect to personal data, and legislation has symbolic value that's important, and we need that in the mix here.
So before we turn it back to Dave for questions, we have one more topic that Danny wanted you to take the lead on, because you've done such important work in this area, which is alternate regulatory efforts. So what else is there besides legislation or FTC rulemaking?
So thank you. I think that and you can go to the next slide. I think that we understand that actually a lot of the privacy rules that we all live under in practice are in fact rules that were in the US that were developed in negotiation between various industries and the Federal Trade Commission. In some cases, as in the case of COPPA, there's a legislative underpinning for that. In other cases, as in the whole series of what I think of as enforceable codes of conduct that have been developed between the FTC and the online advertising industry in various forms. These are obviously complex environments. They're environments that have changed relatively rapidly over time. And I think most importantly, they're environments which the commission realized, if I can say this, it didn't have the ability to police on its own, that there were simply too many players and too much complexity and too much data flowing around to be able to do what I would call original enforcement of FTC Act violation. And so in fact, what the commission did, I think with quite a lot of foresight, going back to the late 90s, was to enlist the industry in helping to build a regulatory process that had, and I won't go into the details because many of you know, but that relied on the industry to build accountability and complaint mechanisms that would spot deviations from the codes of conduct, and an escalation process that eventually, where violations or complaints would eventually get to the commission for action, but where a whole number of complaints could be handled by private sector bodies such as the Better Business Bureau. We're going to have more and more environments, more and more complex data environments that need this kind of what I think of as an alternative regulatory approach. The problem, I think, and the reason I think we still need legislation is because, number one, I don't think the commission always has the strongest hand in these negotiations, and I regret that as a consumer. Number two, I think there's some real transparency gaps in the way these codes of conduct get negotiated. I think some of that has been addressed in the GDPR, which is a good thing under Article 40 and 41, I think it is. But these are for the most part, with respect to the Commission, informal processes which have the benefit of flexibility, but the cost of lack of public accountability and oversight. So I think that building the ability to continue this kind of negotiated rulemaking, you might call it, or enforceable codes of conduct, I think is going to be essential going forward, because I don't think it's going to be possible certainly not for Congress, and probably not even for the FTC itself, to anticipate all of the complexity of the data analytic environments that are going to need to be regulated. And while I don't think any of these existing codes are perfect, I think they actually have brought quite a lot of stability to important markets, and I think they have provided a baseline of consumer protection from which people can then argue they need more, and that's a very legitimate thing to do. But I think we shouldn't pretend that it's going to be possible to have abstract, isolated rulemaking processes that are going to answer all these questions, because I just think the environments are going to be more technically complex than that, and more rapidly changing. And I don't think anytime soon, unless we think the Commission is going to increase its enforcement staff by several orders of magnitude, that it's going to be possible to do this enforcement just internally. So we need to be able to work towards these kinds of alternative regulatory structures that still enforce clear principles with legal certainty behind them.
Great, thank you. Commissioner Wilson, if you want to add something, and then we need to turn it back to Dave to pose any questions and do the wrap up.
No, I think I would just say that I agree with much, if not all, of what Danny just said. I think that self-regulatory approaches can be incredibly crucial in dealing with sort of the nuances of different sectors and different niches, and because those industry members are the ones closest to the practices and the types of data, they are the ones who are sort of on the cutting edge and able to adjust the self-regulation as need be to take those trends into account, rather than going through rulemaking changes. And so I'm a huge fan of self-regulation. That sort of goes hand in hand with my aversion to regulations and rulemaking generally. And so I agree.
And our only difference is that I call it alternative regulation, but that's fine.
Very good. Thank you. So Dave, let me turn it back to you.
Terrific. Well, thank you all for a fascinating discussion. As you can see on the slides in front of you, some resources have been provided by our panelists for further study on this issue. Of course, much is still to be coming. We only have a couple minutes left, and I know we have a hard stop. One quick question that's probably deserving of another session on the webinar, but maybe over to you, Danny, first for this. One of our audience members is asking about what role rules regarding international transfers might play in federal privacy legislations. Specifically, can the panel talk about international issues, what legally needs to happen to address Schrems 2? Federal privacy laws or regulations won't address cross-border issues if it doesn't address the national security question. Again, probably topic for another whole session, but any quick thoughts on that?
All I'd say is we need federal privacy legislation so that we can have an adequacy determination from the Commission. That's an entirely different place to start the discussion than with this series of creative but unusual agreements that people are not even quite sure how to characterize from an international law perspective. I think that there's going to be, probably for some time, a certain amount of uncertainty associated with the behavior of the very independent, appropriately independent European court system. But I think we would be in a much better place if we behaved and were treated as a peer with our own privacy law, rather than as a elephant size anomaly. So I think that would help us get to a better place.
Thank you, Danny. Commissioner Wilson, any follow-on thoughts there?
No, but there is another question. Someone notes in the chat box that legitimate interest is very strictly interpreted under the GDPR, and in fact, business purpose under the CCPA is probably broader. And that goes back to one of my concerns about GDPR. In the United States, we have right now what is called permissionless innovation, right? We don't have guardrails, and I would like guardrails, but I want people and companies to be able to explore new ways to use new data and new analytic techniques. Permissionless innovation is one of the things that has made America great. We have a fantastic, thriving, robust tech sector, and it is precisely because we don't have a mother may I type of approach. And so I do want guardrails for businesses and transparency for consumers, but I don't want it to come at the cost of stifling innovation and inhibiting competition.
Terrific. Thanks very much. Well, and with that, unfortunately, we're out of time. Commissioner Wilson, Danny, thank you so much for agreeing to be on the panel today. Maureen, thank you so much for organizing, moderating, bringing the topic to us. It was really a terrific conversation. And thank you to BakerBots for sponsoring the program and making it free and available to all of you out there in the IAPP audience. It's your support is very much appreciated by us here at the IAPP, especially during these challenging times that we've just come through. So thank you all very much. It's very much appreciated. Want to let you know that there are other programs that are available in the IAPP library. You can find them in the IAPP store. So you should go over there and look for them. So there are many more titles that are available. We've been very busy over the last few months on topics that you may have interest in as privacy professionals. So with that, one last time, thanks everybody for joining us today. It was really a great pleasure. Hope to be able to repurpose this at some point in the near future. Stay safe and well, everybody. And with that, I'll take us to a program close.
Thank you, everybody. Take care.
Thanks so much.